Welcome to the Divorce Podcast, a podcast that aims to address divorce, separation and co-parenting here in the UK, countering the often sensationalist way it's portrayed in the media, challenging the status quo and driving for reform. On each episode, I'm joined by experts to discuss divorce, separation and co-parenting from different angles and to give their opinions and to debate them. I'm Kate Daly, a relationship counsellor and divorce coach, co-founder of Amicable, the divorce services company, and host of this, the Divorce Podcast. In this episode, I was joined again by the wonderful legal queen and her dogs. Tracey Maloney, who's well known on social media, previously came to bust some divorce and separation myths. If you haven't already had a listen, go to episode 58. Tracey has worked in family law for almost 20 years and has practiced as both a barrister and a solicitor in Australia and here in the UK. She was head of the family department for a nationwide legal firm and is an associate lecturer in family law at the University of Bristol. We spent this episode busting common divorce and separation myths, such as whether divorce will be automatic with the introduction of no-fault divorce, whether you need to split your pension or inheritance when you separate, why you may need to disclose your finances, and also myths around children and custody. This episode covered the most commonly asked questions about divorce and separation in easy, digestible snippets. I loved recording this episode with Tracey, and I'm sure we'll have her on again in the future to bust more of those divorce and separation myths. If you really loved this episode or want to hear more episodes like this, then please make sure to rate us on your preferred listening platform. Enjoy the episode. I'm delighted to be joined again and back by popular demand by Tracey Maloney, the legal queen, and we're going to bust some more divorce myths. So I'm going to get straight into it and ask you, Tracey, no-fault divorce. Will it make divorces automatic? So the new legislation has removed blame from the process, but will you now just be able to say you want to get divorced, send off a document, and then you're divorced? What happens?
Hey, Kate. So no, and I get asked this all the time, it won't make them automatic. You still have to go through the same process as we have always had. You will send in a divorce petition, the other side will confirm they have received it, and then you'll proceed to your decree, nice side decree absolute, which is now not called that anymore. So it won't make it automatic. No, the only thing that's changed is there's no blame anymore. So we don't have to decipher if there's been unreasonable behaviour, adultery, or periods of separation.
Great. So it's a simpler process in that we don't have to, like you say, apportion any blame. But there's still a process to go through. So it's not, you don't just apply and it happens. There are still steps and stages that you need to go to, and you need to apply at each step and stage. So that brings us on to another question. Is it quicker to get divorced if you have no assets to sort out or you've been separated for a while?
So no, it's still going to take those 26 weeks, possibly a little bit more. The assets is a financial order that's completely separate, Kate, to the divorce process. So it's not going to make it any quicker, even if you have no assets.
So there's a standard process. It takes a standard amount of time. So if people see, advertised, quick divorces or anything like that, effectively, there is no such thing as a quick divorce anymore. It's just going to take the time it's going to take.
Absolutely. You can't rush the process. There is a process that the court wants us to follow, and that's set in stone.
You mentioned financial orders. Just tell us what's a financial order. So if you get divorced and you've got assets, you need a financial order as well as a divorce?
You do, because all the divorce will do, Kate, is sever your marriage, okay? It just brings the marriage to an end, which means that you can go on and remarry legally. What it won't do is sever the financial ties. A financial order will sever the financial ties. And if you don't sever your financial ties, that means that at any time after decree absolute, you can come back and still make a financial claim against your ex. So it's really important to get that financial order in place.
Right. So the financial order is also called a consent order, isn't it? So I know sometimes it's confusing because people use different terminology. A financial order can be called a consent order, and a consent order is when you've both agreed it together rather than a court has handed it down. Is that right?
Correct. Yeah, that's absolutely right, Kate. It can also be called a clean break order, where people have no assets, but we still need to sever the financial ties. So then nothing goes into the order because we don't have any assets, but it's a clean break. So we're just saying to the court, we have no assets, but we want to sever those ties.
Yeah, because you're right. There was a case recently, wasn't there, where a husband and wife had divorced when they were young, and then the husband had gone on to make millions, and they hadn't had a financial order or a clean break order, and the wife came back and claimed money, didn't she? So it's
That's
not
right.
just
Yeah.
a theoretical risk; it's a real risk.
No.
For
It's
people.
it's a real risk, and that particular case, they had their decree absolute for over 20 years, and she happened to see him do a local piece in the paper. He'd gone on and was worth 18 million, and she saw a local piece in the paper that he was doing something for charity, and she thought, oh, okay, we didn't have a financial order. She made a claim, and she walked away with 1.8 million.
Yeah. So the moral of that story is, even if you've got no assets, it's worth that little bit of investment,
Absolutely.
making sure that you're financially separated as well as divorced and legally separated.
Yes, absolutely.
Okay. And another question I get asked a lot is around financial disclosure. So if you're going to do a clean break, or you're not doing anything with the kind of, you're not swapping any assets, do you still have to disclose?
You do, Kate, particularly if you're going to go and see a solicitor, because the court's going to want to make sure the order's fair and reasonable. And of course, we don't know if the order's fair and reasonable if we don't get a full picture of both parties' finances. And we always have to be aware that one of the parties could be vulnerable. And what I mean by that is, you might have had one of the spouse hide money, put money away. Maybe they don't know how much their spouse is actually earning. So when they come to us to say, we just want a clean break, we don't do any disclosure, we have to say, well, hang on a minute, let's just make sure that actually this is going to be a fair and reasonable settlement.
So, and as well, if you're asking the court to make a clean break order, you have to fill in a second form for the court, don't you, called a statement of information, or a D81. And that sets out what each person has in terms of assets for the court. So the court can then have the evidence to see whether each of you not swapping any assets is actually fair.
Yes, that's right. I mean, the court don't want to see the physical disclosure, but they do want you to complete that form so that they can get a real overview as to what your financial position is, both before the order's made and after the order's made.
Yeah, absolutely. And another question we get asked a lot is, if it's an amicable divorce and you're just, going to split assets in an amicable way, is 50-50 always the fair way to do things?
No, not necessarily. That's our starting point. We will always start at 50-50, and then we'll look to see if one of the party maybe needs more or needs less. And the factors that we're going to be looking at will be, for example, the age of the parties, the earning capacity of the parties. Do we have any young children involved that one of the parties has to possibly rehouse? So no, that's our starting point at 50-50. And then from there, we will make any necessary adjustments.
Because that's really important, isn't it? Because a lot of people think 50-50, that's fair. But if one of you does earn a lot more money than the other person, and therefore has a much greater mortgage capacity, for example, that can make a really big difference to your ability to house yourself, and mortgage capacities should be taken into account there.
Yeah, absolutely. Or perhaps one of you has a medical condition that's prevented you from working, and therefore, you're not able to work. So you may actually need spousal maintenance from the other person, and we're moving away from 50-50.
Yeah. And then I guess the other thing on that is that the court is going to look at certain things, as you said, to determine whether or not a settlement you've come up with is fair. So even if the two of you both agree that this is what you want, the court's not necessarily going to sign it off if it's unfair.
Correct, absolutely. And I think we can help, we being the solicitors, because obviously we'll get an understanding of why the parties want to agree that particular settlement. And if there are exceptional circumstances, for example, maybe a lump sum has come from a premarital asset or an inheritance or whatever, we can sometimes explain that to the court. But yes, the court's going to be very keen to make sure there's three umbrellas really, Kate, that we have to look at. The court's going to want the housing needs of both parties met, the income needs of both parties met, and the capital needs of both parties met. As long as we can tick those boxes and it's fair and reasonable, we should be okay.
Okay. You mentioned inheritance there as well. How is inheritance treated? So if I inherited from, say, one of my parents a long time ago, and I put that money towards the marital home, so it was part of the deposit or whatever, do I get that back out at the end? How is inheritance treated?
If you've inherited it a long time ago, then it's probably going to be considered as being absorbed into the marriage, okay? So if you haven't had it, but it's imminent, we can sometimes try to ring fence that. If you've just had it, we can sometimes try to ring fence that. And generally, the courts do like to keep inheritance ring fenced. We'll only draw upon it if we need to. So, for example, if the existing matrimonial assets won't allow us to satisfy both parties' housing needs.
Right. So if you can't rehouse, then you need to use the inheritance to help make the settlement work.
Yes, okay. Absolutely. Yeah.
But if you can sort everything out and inheritance has been kept kind of separate or out of the mixed up assets, like in an individual account and it hasn't been touched or it's been used for certain things, then there's more chance, it sounds like, of getting that ring fenced in those circumstances.
Yes, absolutely. Yeah, okay. Absolutely.
All right. The other thing that we looked at and just talked about was pension. So there's a big report out today all about pensions, saying how many women don't get what's due to them in terms of pension on divorce. And there's a lot of pension poverty for women in particular. What's the rule with pension? Is pension an individual asset? Is it a marital asset? How does pension work on divorce?
It's definitely a marital asset, Kate. And the starting point again is that all contributions made during the marriage are to be divided evenly. So regardless of who's paid into a pension pot, we look at everything that's been paid in during that marriage, and then we're going to divide that. I think that potentially where women are falling down is maybe where they've obviously been off work for a long time, having children, haven't been able to pay into a pension, and perhaps their spouse or ex-spouse's pension contributions were made maybe prior to the marriage. So I think where a pension contribution is made prior to marriage, we wouldn't include that. So it can make the overall pension share sometimes look unfair because we can only look at contributions made during that marriage.
And how do you separate them out then? So I know when you get divorced and you're going to look at assets, you apply to your pension company for what's called a CETV, a cash equivalent transfer value. How do you separate pre-marital contribution?
Generally with the help of an actuary. So if we're going through the divorce and we notice that the significant contribution made pre-marriage, we will then call on a pension actuary to do us a report. And they're far more skilled than us solicitors at being able to separate that and letting us know the amount that we are looking to divide between the parties.
And I know that for some people, they divide pensions just on the CETV value. So you might just get your CETVs, add it up, yours, your partner's, divide by 2, and then do a share that reflects that balancing out process. Is that okay?
It can be. I mean, again, it depends on the type of pension they have. We're going to look at if any pensions are in drawdown, obviously making sure that all of those contributions are made during the marriage. And of course, if the parties are happy to do it that way, yes, there's a variety of ways, Kate, that we will divide the pensions. But yes, sometimes we will work on the CETVs. If they're small CETVs, that's more favoured. If obviously they're large, say, police pensions, military pensions, MOD, something like that, then we're going to be looking to bring in a pension actuary.
Yeah, because those schemes are usually defined benefit or final salary schemes, aren't they? And CETVs aren't very accurate at representing the true value of those kinds of pensions. So you can get a very misleading kind of division, can't you, if you just add those up and divide by two. But with SIPs or with defined contribution schemes and smaller pensions, as you say, it's not unacceptable to do it that way. And it's quite a pragmatic way of doing it for lots of people, isn't it?
Absolutely, yeah. And of course, some people don't want to encounter additional fees for the actuary. And particularly if they're happy that they've made the same sort of contributions during the marriage, we have, relatively low figures. Maybe one of them has 10,000 and one of them has 12,000. They're more than happy to then just go off the CETVs.
And that seems to make sense because we want to keep it pragmatic and cost effective for as many people as possible. And I always think there's lots of advice out there, but if your assets are smaller, then sometimes it's not worth the investment, even though these are things that lawyers will always say you should do. You should always get an actuary. But if you're having to spend $2,000 on an actuary,
absolutely. And the time it takes.
Yeah, exactly.
Yeah, I mean, at the moment, we're waiting anywhere between 16 to 20 weeks for the actuaries to do their report. So it's a long time, for people who perhaps want to just move on and get closure.
Yeah. And I guess one of the things that's quite interesting as well is we get a lot of times where, particularly, and I don't want to be too gender stereotypical, but it does tend to follow a pattern where women in particular are really keen not to lose the house and will sacrifice pension in return. Is that as dangerous as it seems?
Look, Kate, it will depend on the family. Okay. I mean, I always say this to people in family law. Whilst we have our legislation to follow, family law is very bespoke to the needs of that individual family. And typically the reason why the wife wants to remain in the property is because generally the children stay with the mum. So what the wives are trying to do is, and the husbands, to be fair, the mums and the dads, they're trying to keep consistency for the children. So by enabling mother to stay in the property and therefore give the children consistency because the parents have just broken up, she may then forego some of that pension. Is it fair? Maybe not long term for her income needs. But then if we're talking about a lady that's maybe in her early 30s, you could take the view that she's still potentially got 30 years to then put into her pension. And of course, the flip side for her is she has more equity in the property.
Yes, potentially, providing there is equity in the property, then yeah, absolutely. And ultimately that property could be sold when the children don't need the property or need to be in that area anymore, downsizing, releasing equity and all of those. So there are options around that. There's also the option of a measure order. Do you want to just explain what that is as well? Because that's another way of enabling somebody to stay in the house, but not necessarily take all of the equity in the house, and therefore to have a more balanced sort of end point with a bit of equity from the house and a bit of pension as well.
That's it. So the measure order is almost a delayed order whereby we recognise that both parties who own the house jointly are entitled to 50%, but that one of them will agree to delay receiving their 50% until the youngest child is 18. So if we take our typical situation where father moves out, mother stays in the property with the children. Mother recognises that father's entitled to 50%, but she can't buy him out. So once the youngest is 18, it's at that point that we can then either sell the property and divide the equity then, or mother can buy him out at that point. Or indeed, father could buy her out at that point. So it's almost a delayed financial order, really.
Okay. And you mentioned there about, I think you said earlier that mother often gets the children. Is this still the case? Do women tend to get care of the children? Or if a dad is really involved and wants to have a 50-50 shared care arrangement, is that more likely these days?
You know, Kate, again, it does depend on the family, but the cases that I see, it's typically the dad that works full time, and it will be the mum that stays at home and looks after the children and then maybe goes back to work part time. So when parents separate, what the court are looking at is what are the children used to? What is the status quo? Because they're trying to keep that status quo for the children, and therefore children stay with mum and have contact with dad. Because with the best will in the world, a lot of dads can't have 50-50 because their work hours won't allow them to. That said, there are, especially after COVID, lots more fathers who are now working from home and able to have the 50-50, which is great. So I am seeing a slight change in direction here, but it's not because the court favours mums. Court favours the children, and they're just trying to keep the status quo for the children.
I think that's a really important point, isn't it? Because sometimes we get, people feeling quite exercised about it, but it is the court's perspective is the children's best interests. So it's not that the children are better off staying with mum. It's the practicality. So if you are in a situation where you don't have those kind of very old-fashioned, almost traditional ways of working where dad works and mum stays at home, if you've gone beyond that and you have a much more equal partnership, there is no reason why you can't share care. There's nothing that says women have to have the majority care of the children anymore.
Not at all, not at all. And again, shared care, so long as it's in the best interest of the children. I have some parents that say to me, well, can we have the children for 2 nights, then back to mum's for 2 nights, then back to dad's for 2 nights, and so on and so on. And that really isn't in the child's best interest. So again, with the best will in the world, we will try to accommodate 50-50 so long as it causes the children the least disruption as possible, because of course it's the children that are backwards and forwards between the two houses.
Yeah, and there are lots of different patterns you can adopt depending on the age of the children that you've got now as well, aren't there? So we know a lot more about what works, and as they get older, I know lots of older kids prefer week on, week off because that minimises disruption. Younger kids sometimes can't tolerate being away from one or other of the parents that much. So you do have a slightly more broken up pattern with a bit more toing and froing. So it seems like we know a lot more about how to make this kind of stuff work.
Absolutely. And a lot of parents will have maybe week 1 and week 2 scenarios where on week 1, dad has them for 3 nights and week 2, he has them for 4 nights. And vice versa. So yeah, lots of patterns. Again, everything's designed to suit the children and that particular family, Kate.
And do you think you have to be amicable as a couple to make those kind of shared care arrangements work?
I do. My view is absolutely you do, because you still have to co-parent. The families that get a court order, I think, then think, well, that's it. We don't have to deal with each other. We just follow the order. It doesn't work like that. You still have to co-parent. If a child is sick and potentially can't then stick to the court order, you need the other parent to be gracious enough to say, that's fine. I get that you're having some extra time, but that's because the child isn't feeling very well. And, we'll look to make up that contact another time. So, yeah, they do need to get on. It's in the kid's best interest at the end of the day as well.
And also we have what's called the no order principle, don't we? Where we have this idea that we won't make orders for children unless we absolutely have to. So most parents are expected now, aren't they, just to keep arrangements informally between themselves? Absolutely.
And we have parenting plans that parents can download from the court website, the government website, so that they can it's not an order, but it's something they can work on together and, decide what happens at Christmas and what happens during the summer holidays and what happens if a child is ill and childcare arrangements. And the court's always promoting that because we're trying to encourage co-parenting all throughout the separation, which can be difficult enough, and that's when emotions are running high. When mum and dad have made the decision to separate, it's very difficult then for parents to put their feelings about the separation to one side and be very amicable and look to co-parent together. That's where the clashes come in.
And I'm going to make a shameless plug for the Amicable Co-Parenting app here as well, because you can do your parenting line in an app and you can have a separate channel for your communication. So all your children communication is all in one place, not mixed in with your other WhatsApps and everything else. And there's a shared calendar too. So if you're interested in co-parenting in a really amicable way, then do check out the Amicable Co-Parenting app.
Such a good idea.
Thank you. Tracey, it's been absolutely brilliant talking to you again. Thanks so much for busting these myths. It's been a real pleasure. And hopefully we'll see you again soon.
Absolutely. Thanks, Kate.